Mr. Vice Chair. During the 88th legislative session, the legislature passed House Bill 1432, which essentially repealed the requirement that courts find a likelihood of future family violence before granting a protective order. What that did, members, is mandated the issues of a protective order, even if any past violence is proven, regardless of how long ago it occurred. Courts are now compelled to grant protective orders based solely on historical incidents, which may longer reflect the current dynamics between the parties. This change in law has undermined the purpose of protective orders, essentially punishing persons for past wrongs or prior criminal acts, rather than seeking to prevent the applicant and prevent future family violence, increasing the risk that a parent could lose joint custody rights based solely on a single historical incident of family violence. This bill addresses this problem by providing for an affirmative defense to applications for family violence protective orders, thereby safeguarding the fundamental liberty interest of the parents. And so that's essentially what the bill does, and I'll be happy to answer any questions, but I think there may be several witnesses here to testify, probably both for and against the bill.
Right. Thank you, Mr. Chairman. Is there any, are there any initial questions for Chairman Dutton? If not, then we will begin with the witnesses. Let me begin first with Cecilia Wood. I have you, Cecilia Wood, testifying for yourself, board-certified family law attorney, and you're testifying for the bill.
That is correct. My name's Cecilia Wood, and I'm testifying in favor of this bill. Let me start out, because sometimes when I take a position like this, people think I'm in favor of bad actions. I am not in favor of family violence in any way. What I'm also not in favor of is that it has become evident to me over the years in my practice that there are attorneys who let their clients, they ask, has there been family violence? They let their clients know because there are benefits to the alleged victim if there's family violence. There could be benefits in the division of property, in the possession and access to the child. There's so many things, and I have had cases where the victim is actually set up, either set up intentionally. I mean, I had one case where the young woman left a situation where they were all together, waited till my client returned to the house, and brought the baby in with him, started undressing, and then she started making noise, and he went into the baby's room to see, and there was a fight that ensued because he thought his home was being invaded, and she was on the phone with her father. This had all been set up, but it happened. He won the fight, so he went to jail, and he had the protective order issued against him. That, in my day, when you needed help, there were no protective orders. Literally, you would call, and the police would say, well, is he still there? Well, yes, and I asked for a timeout, and what I do not want to see happen is this be misused, and I think that by putting it in as an affirmative defense, the court can still find that there is a likelihood of violence because maybe there's been a past history or there's a person that has a drinking problem or whatever that leads to this. But it also protects people from being just used for just being used. In some counties, they're going to arrest somebody, and that's not what protective orders are meant for. And I would hate to see this pendulum swing like it does in some counties where I practice. They don't even take them seriously. I think it's getting a little better, but I think this is a great way to split the baby, so to speak, and give judges discretion for each case. And I hope you pass this bill.
Thank you. Members, any questions?
Thank you. If someone asserts an affirmative defense, must the judge, because affirmative defense is different than defense, right? Or is that just a criminal thing versus a civil?
Well, an affirmative defense, the person asserting it has to prove. So the affirmative defense might be, you know, we never had a problem. I said I was gonna leave. She tried to stop me and took my keys, and, you know, she got hurt.
But-
But the person that's, so the
Yeah, the burden
alleged
shifts.
perpetrator, yes, it would shift to
But
prove
assuming
it.
they prove it, the judge, at least in theory, must.
Well, yes.
Okay.
Well, the judge would have to find, I mean, if they proved it, then the judge would find that there was no future danger to the situation. And sometimes these are one-time incidents that, you know, just people got drunk or got in an argument. Sometimes it's been far in the past, as Chairman Dutton
No, you don't
said.
have to sell me on it. My only concern, my only
But I
concern,
want
my
to.
only concern is whether or not someone asserts an affirmative defense, and the court can disregard that and still make a finding of a protective order. Because I agree, the old law of family violence has occurred, and family violence is likely to occur, I think, in the definition of protective order versus a one-time incident versus a continuing incident. So my only concern is whether or not an affirmative defense is at least in theory, right? Courts ignore the law, but whether or not it's binding, at least in theory, on the court. If you
Yes.
prove it, okay.
I think it would be.
Thank you.
Any further questions?
Judge Hayes.
Thank you, Ms. Wood, appreciate
Thank
it. Our next witness will be Sherry Evans. Ms. Evans, I have you down that you are here for yourself and the Texas Family Law Foundation, and you're testifying for the bill, is that correct?
That is correct, Chairman. Thank you, Chairman Dutton, and good evening to everybody, and thank you for staying late. A lot of my testimony will be repetitive, so I will go quickly. But as Chairman Hayes said, my name is Sherry Evans, and I'm here on behalf of the Family Law Foundation and as an individual attorney, board-certified attorney practicing in Harris County and many of the counties surrounding Harris County. And I do believe that our intent here is very simple. Representative LaHood, as you pointed out, to remedy a situation that has arisen over the last 2 years, and that is in removing that second prong, and that is that family violence is likely to occur in the future. What we've seen over the last 2 years is a floodgate of litigation occurring in the context of a family law situation. When parties are going through a divorce, an incident that may have happened 5, 6, 7 more years ago are now being used as a single incident to come in and to be used as leverage in a custody case when that was never the intent of the protective order statute. I want to be very clear, and I think everybody has made that clear, but I want to be very clear that our intent here is not to change the burden of proof on the victim. We want the victims protected. What this does is simply shift the burden to the defendant to plead and to prove as an affirmative defense that second prong that had always existed, and that is that family violence is not likely to occur. And as you pointed out, it's simply a shifting of the burden. Two things I do want to point out that haven't been mentioned. The reason that this is so significant is that if you keep in mind that our statute, our protective order statute, is mandatory, it is shall. So without this, courts can find that if there was family violence, irrespective of the fact that it was many, many years ago, they are mandated to issue a protective order. And second of all, there is no statute of limitations in the statute. So that's why you have these incidences that are many, many years ago being used as a single incident to support a protective order many years later. Thank you very much.
Thank you. Members, any questions? Thank you so
Thank
very
you.
much, Ms. Evans, for coming and testifying all the way from Houston. We'll call next Honorable Carl Hayes. Judge Hayes, I have you registered on behalf of yourself. If you are an Associate District Court Judge, Family Law Court over in Hayes County, and you are not testifying on behalf of Hayes County, but on behalf of yourself. Is that correct?
That is correct.
And you are for the bill?
I am for the bill. All right, well, you already put that on the record, so I won't cover that. I am testifying in favor of HB 2282. And Representative LaHood, I know we can't pose questions to you, but just hypothetically, you have to think about why it is we had that second prong in the first place. And the reason we had the second prong in the first place was in order to make sure that the statute was constitutional, because you're infringing upon an individual's rights when you impose a protective order. You take away their right to hold a handgun. You may take away their right to see their children. So the state has an interest. And when the Title IV was first adopted back in 1979, the legislation clearly said that the compelling state interest is to protect victims of family violence. But you also know that when the state imposes something to protect a compelling state interest, they have to have a narrowly tailored resolution of that. And the narrowly tailored part of that was to say, look, we're going to render an order if there is an imminent danger and a need to protect the person. When you have someone coming into court saying, well, I was injured 3 years ago, and I can prove I was injured 3 years ago, nothing's happened since, the person I may even be in a relationship with them, but I'm now entitled to a protective order because of what happened 3 years ago, that defeats the purpose of why we were trying to protect individuals. Because and I'm going to read from, there's an excellent Court of Appeals opinion, and if any of you want to write the cite for this down, it's 493 Southwest 3rd, 624, and it's the Dallas Court of Appeals opinion, and it's Roper versus Joliffe. And in that, they talk about the enabling legislation back from 1979, and the court says this: the purpose of the statute is to provide an expedited procedure for victims of domestic violence. The purpose is not to correct past wrongs or establish liability, but to give immediate protection for the applicant. And by taking that second prong away, it's now more of a remedial, it's a punishment. We're saying, look, you did this, now this person deserves a protective order, not because they need the protection, which in some instances they may need. We've done a survey, and we're still working on it, and we've got to fine tune it, but we looked at all the other states, and the majority of states have a second prong requirement of looking at this and saying, looking at this situation and saying, family violence has occurred, but there's an imminent risk of it occurring in the future. Because what you want to do is protect the victim. You don't want to punish the person who committed the offense, because you can do that through a criminal offense, or an assault, a tort case against them. What you want to do is protect the victim. And again, you go back to a situation, my poster child case, I had an attorney come into the court because I handle all the protective orders. It was an event that occurred 8 years ago. And I sat there and I said, do you really expect me to grant you a protective order based on something that happened to your client 8 years ago, when parties remained married, nothing else had ever happened, they had one incident 8 years ago? And the attorney said, yes, Judge, because the statute says you have to. The statute says it's mandatory now. Like you said, some judges don't have to always follow. And I said, I'm sorry, I'm just not going to, you can take me up on appeal, I'm going to find latches, I'm going to find waiver, I'm going to find everything, because I just don't think that's what was intended. But that's what the law says. And unless we fix this, and the way we fix it is either we put it back the way it was, or shift the burden and put the burden now on the person who is accused of committing the family violence to come in and say, it's never going to happen again. And let me show you it's never going to happen again, Judge. And that takes the burden off of the victim, the survivor, from having to come in and do that. It gives the court the ability in those cases where the facts and circumstances support it, they're able to prove it, to where a court isn't required because to render a protective order. Because the problem we're seeing, we saw a threefold increase in the number of protective order applications being filed, and the reason for that is 153-131 of the Family Code says that the presumption that is in favor of joint managing conservatorship, that both parents are equally capable of taking care of a child, and that presumption goes away when there's a finding of family violence. So just as Ms. Wood said, some attorneys will come into court saying, look, you're gonna get the advantage if we can do a protective order, get a finding of family violence, then you cannot, you can't be a joint managing conservator with him, you're gonna get sole custody. And that's not what the purpose of the protective order statute was for, and I'll yield myself. So we're urging you to adopt this, or I'm urging you to adopt this, and so I'll yield to questions.
Thank you so much, Your Honor. Any questions by the members?
Thank you.
So much, Judge Hayes. Our next witness is Damienne Kirby. I have you registered to testify on behalf of yourself, but you serve as the judge of the 280th Judicial District Court, but you're not testifying on behalf of the district court.
That's correct.
And I have you registered for the bill.
Yes, thank
Thank
you. Thank you so much, Chair Dutton and Vice Chair and everyone on the committee. I am here in favor of this, well, it's not the second prong anymore, of the affirmative defense. And mainly because I don't need to repeat what everyone else has said. This is new. What it does, when it takes the burden off the judge and places the responsibility on the respondent, it is he or she who has to admit that they committed this offense. And most of them will not admit that they did it. And so for me, that's contrition in itself. They take ownership for what they've done, and then they prove that they won't do it again. The issue that I saw was in proposed section 82.023 subsection 2, where the judge has the discretion to issue what I call twin protective orders, and that means giving them out mutually. A lot of people use the protective order court as a way to get back at that person who put a protective order on them. And I believe that if a person wishes to have a protective order to protect them, they need to file an application, they need to file an affidavit, they need to go through all the processes the same way that the applicant did. Otherwise, as the judge, it's a swearing contest between these two parties, and I don't know who's telling the truth. But if I have an affidavit here, I can hold them to what they've written down. And so as opposed to just saying, I'm going to give it to both of you, and both of you stay away from one another, then you actually have something that you can look at, and you can say, yes, this is what he has testified to, this is what she has testified to, and what they have written lines up with what they've testified to. The good thing about 82.023 Section 2 with the twin protective orders is that they are very helpful as it pertains to love triangles. And of course, that's where you've got one person who's at the center of this and two people, whether it's men, women, or sometimes a man and a woman, who are vying for the affections of that one person in the middle. They could benefit from a mutual protective order. But in most cases, you won't see 82.0232 played out in actual court. You won't see it. The cons that I had for 82.023 as on its face is that people become vexatious litigants. We don't want people to use this as a tool to hammer the person who is considered the victim. Everyone needs to go through the same processes if they wish to have a protective order. And as the judge, I don't want anyone coming in with an old allegation asking for a new protective order simply because they have a pending divorce or a SAPSR. So I think that adding that phrase would be good. The affirmative defense would be good, but I would definitely look at 82.023 subsection 2 and reconsider whether or not they need to file their own application or whether or not a judge can sua sponte, just decide, I'm going to give multiple or mutual protective orders. Thank you.
Thank you, Your Honor. Thank you so much for coming and testifying. Any questions by the members? Thank you. Our next witness will be Nemi Lokai Sain Kina. I'm pronouncing that correctly.
Yes, you do. Thank you, sir.
I have you testifying on behalf of yourself.
Yes, at this time I'm testifying, thank you so much.
Hold on, you testifying for yourself, and I have you testifying against the bill.
I'm testifying against the bill, and I would like to add that I'm also testifying about, I think we're getting well acquainted now. I'm testifying against the bill for myself and for Keep Girls Safe Foundation, an organization that I founded as a survivor.
All right, slow down for just a minute. And what foundation?
Keep Girls Safe Foundation.
And could you be kind enough to spell that for us?
Absolutely, sir. K for kite, E for elephant, E for elephant, P for Paul, G for good, I for internet, R for Ryan, L for lion, S for Sierra, S for Sierra, A for apple, F for Frank, E for elephant, Foundation. It is registered in Kansas.
Okay, Keep Girls Safe Foundation.
Yes, sir.
And is girls safe two different words or one word?
No, it's different words. I just spelled, sorry. Yes.
Go ahead.
It's a 501c status. I'm wondering if it's okay with all of you if I should actually speak this way. And the reason why I was wondering, because everyone that has testified here, if I'm allowed to, I've seen attorneys testify, I've seen judges testify. What I wanted to know, and I don't want to make this personal, are the judges survivors of domestic violence? And
Well, to answer your question, you're gonna testify to us.
yes,
We're in the fact gathering stage.
okay.
We wanna gather as many facts as we can, and then that will help us evaluate any proposed legislation or proposed changes.
All right. The reason why I was asking that question is because when I was sitting right there, I was actually getting triggered by what I was hearing from the judges and from the attorneys that were talking. This is why I was getting triggered. These are the words that I wrote down.
All right, I want you to testify on the bill.
Yes, on the bill.
Regards
Yes.
as compared to what someone may have said to you.
Yeah, that's the bill, not to me, what I was
That you
hearing on
overheard.
over the bill, for the bill. So I was hearing, I apologize. I was hearing affirmative action. I'm not an attorney. Basically, it urges that, but the affirmative act, what it meant to me is that the burden is taken away. The burden now is given to the survivor to be able to prove, and the perpetrator to be able to prove that then the perpetrator is not going to do it again. In my case, so let me testify about my case. My perpetrator stood in front of the judge in 2002 and said he will never do it again. I had filed for a divorce. We were sent to a counsel. Two counsel attorneys came together, and they sat down, they talked about it. The case was withdrew because they believed him. At that particular time, we were in Alaska. He had abused me. I was in the hospital for 5 days, but they still believed him. I don't know how I was manipulated. We ended up in Kansas from Alaska, originally from Kenya, Alaska, and then Kansas. In 2023, November 7th, he did it again in Kansas. He went in front of a judge and said, I will never do it again. In 2023, 2004, he did it again. I did not call the police this time. Why? Because he told me if I call the police, he will kill me. In 2007, I ended up in the hospital again. he still manipulated me with a left triangle, and I was able to go back to him. I carry those scars today in my head, in my body, and in my soul. That's not a one-time thing. That's not going to save that person. Yes, they might have hit that woman once. That is somebody's daughter. That is somebody's son. That is a human being. Once does not mean you cannot hurt somebody. You can take somebody once and you kill them. I have seen so many people who have been killed because we minimize things by saying once. It does not take twice. Let me reference a case that just happened in Dallas, Texas. This is a case that just happened in 2025. And I apologize if I'm getting passionate because it is my life and the life of survivors that I'm trying to protect, because my life was protected by another survivor. That's why we're standing here. Another survivor testified, gave their story, felt the pain so that we can have these bills. Taking this bill apart, this is what it's going to do. Frida Costello, 2025, Laredo, Texas. Frida Costello, 20, was fatally shot by her ex-boyfriend, Fernando, during a standoff with the police. At this time of the incident, an emergency protection order was in place against Machado, following a prior arrest for attempt. I don't want to go on, but I'm just trying to say this. Please, before you bring this bill and allow this bill, I want you to, please, I'm begging you, if no one has ever begged you, I want you to think about your daughters. I want you to think about your sons. And I want us to do this thing and do it right. I have suggestions that I have here. And if it's okay, I will forward them. And let me just list them so I can sit down and allow other people to do what they need to do. This is what the affirmative defense, in my opinion, will do. Abuser can claim violence is not likely to reoccur. That's what they're going to do. Remove this loophole. It undermines court finding of the past abuse and the traumatized survivors. Let me reference one more bill that I actually testified here in Texas, but not in person. There's a bill, it's a law now, of female genital mutilation. Survivors of female genital mutilation, which I am a survivor of female genital mutilation, a lot of the perpetrators say they will never do again, but they still did it. Right here in New York, in 2021, there was a couple that say they will never do it again, that were found guilty because they mutilated a girl again. Perpetrators don't stop. And just saying that they will not do it again, they are one against the other. What about if this person is not going to be alive and they're going to be a victim? I ask you to please do not pass this bill, because when this bill gets passed, a lot of children, a lot of men, a lot of women will lose their lives. Please, I am a survivor. I am not a victim. And I believe I was kept alive so that I can speak to bills like this. Thank you very much.
Thank you very much. Any questions by the members? Ms. Keenan, thank you very much for testifying and sharing your experience with us. That was very meaningful. I have next Erin Mays. I have Erin Mays, Public Policy Manager for the Texas Council on Family Violence, and you're here testifying neutral on the bill. Is that correct?
Yes, that's correct.
Thank you.
Like you said, my name is Erin Mays. I'm a public policy manager at the Texas Council on Family Violence, the statewide coalition that represents family violence programs all over the state and in your districts as well. I'm here to testify on House Bill 2288. At TCFV, it is our practice to testify on a bill anytime we are attempting to work with the author on a measure to potentially change the language to better support victims. Thank you, Chair Dutton, for this opportunity to speak. Even though we are here today to share our concerns about this particular measure, we are still thankful to Chair Dutton, who has many measures designed to support Texas families. CCFV is confident we can work together to create a safer alternative proposal for this bill. I'm going to speak today about the experiences of the majority of victims. Victims of family violence pursue protective orders because their safety, often their very life, is threatened. These orders are one of the only accessible and effective tools that offer safety from an abusive partner or ex-partner outside of engaging in a criminal trial, which can take months or even years to be finalized. When they are needed, the safety issue is often urgent. Said simply, protective orders help prevent homicides. Unfortunately, HB 2288 seeks to set up an affirmative defense to the protective order process in the Texas Family Code, which is deeply concerning. For survivors who are seeking a protective order due to severe safety issues, this could increase their danger in a myriad of ways, including delaying their access to a protective order while this affirmative defense process takes place, re-traumatizing them as they listen to the person who has used violence against them attempt to block them from their safety remedy, and fostering the ability for those who use violence to engage in post-separation abuse by use of the court system. As we thought, this measure stems from the shifts made in 2023 during the 88th legislature, which included changing the protective order process in Texas to look more like other states. Prior to 2023, the statute required those seeking a protective order to show that violence had occurred and that it was likely to occur in the future. As a result of the passage of HB 1432 during the 88th legislature, the need to show that violence was likely to occur in the future was removed, marking an important step towards advancing victim safety. The occurrence of physical violence is in and of itself an indicator that it will occur again in the future. We know this because it follows a pattern. That can make it tough for victims to prove separately to a court that it's likely to occur again in the future. When we looked at House Bill 1432 originally, there were concerns about the ambiguity of the language, speaking that it's likely to occur in the future. We know this shift is familiar to all of you who were members during that session, as each of you recognized this issue by voting to remove the second requirement for protective orders. Contrary to testimony provided in this and other hearings, our research shows that most states, over 30, operate with a similar framework, meaning the recent shift in Texas law is actually consistent with other states. If this is the concern that HB 2288 is seeking to address, we stand ready to work with Chair Dutton and give him ideas and suggestions, and we would suggest a study on protective order use to address those concerns. In the meantime, we ask the committee to consider the re-victimization and trauma this affirmative defense process would create for survivors, as well as the delays in safety that could occur. I'm happy to answer any questions.
Thank you very much. Members, questions? We see no questions, and thank you so much, Ms. Mays, for coming to testify today.
Thank you for your time.
Appreciate it very much. Is there anyone else who wanted to testify, either for, against, or on House Bill 2288?
Yes, I did.
Oh, I'm sorry, Ms. Saldana. I had you written down here and then overlooked it. The next witness will be George Saldana. I have you down, Mr. Saldana, is testifying for yourself, and you're here to testify for the bill.
Yes, sir. I've had 3 protective orders and an ex parte TRO. And like I've been telling y'all, some of y'all might know a little bit about my story. We had Judge Curvey here out of the 280th in Houston. I got a protective order for taking my 13-year-old daughter's cell phone. I was awarded a protective order for that. Is that a fundamental right? Does that meet a compelling state interest for them to limit my rights? To me, that's a form of discipline, taking a cell phone. But I was awarded a protective order. I've had affidavits filed, and just like she said, the law requires you file an affidavit. But we know in family court, they don't prosecute perjury or aggravated perjury, and that's a 3rd-degree felony. And yet, my rights are being restricted. So I think it's got to be a healthy balance, right, for the scales, that we got to protect the true victims of domestic violence, and we also got to uphold the law to hold those accountable that use the protective order system to gain the advantageous result in their family law cases. But not only that, but we have to make sure we have qualified judges to be able to admonish and see those discrepancies. My ex, she hit me. Several police reports. I can't file anything for domestic violence. I can't get a protective order. The case law says you just have to do it once. I read it into my court record, the case law. I asked the judge to make a finding of domestic violence. My cries went unheard. But then when my ex hit me, it's on the trial court's record, nobody does anything. So we have to make sure that we balance these laws to protect the true victims and then the people that are alleged to have done these bad crimes. I think everybody that commits domestic violence should be held to the rule of law. And if you do that, you're safe, man or woman. Thank you.